I'm often asked by medical providers who I'm discussing workers' comp with is whether they can file a medical provider claim in workers' comp court if the patient hasn't filed a claim. And the answer is yes, but let me qualify that. A patient has to at least have informed their employer that they were hurt on the job. So once that happens, then yes, there's a claim number that's created. The employer tells the workers' comp carrier, one of my workers got hurt, a claim number gets assigned, and then the medical provider is in touch with that carrier with that claim number. So the patient does need to at least file a claim with the workers' comp carrier of the employer. However, they don't have to file a workers' comp claim in workers' comp court. If they don't have to have a claim in workers' comp court in order for the medical provider to file a separate claim, their own claim in workers' comp court in New Jersey because they've been underpaid. And here's typically what happens. So a medical provider starts to see this patient, they get authorization from the carrier for the treatment, or it might be an ER situation where the patient is treated on an ER emergency room basis. So the patient lets the employer know they got hurt on the job, the employer lets the carrier know, the medical provider bills that carrier, the carrier makes a payment. Now under New Jersey law, if there's no agreement between the workers' comp carrier and the medical provider, commonly known as a PPO, the medical provider, as long as they got authorization, was entitled to usual and customary rates. So what will often happen is a surgeon may bill $20,000 for a procedure and the carrier pays them $2,000. These are not exaggerated numbers. Now, we take the position in workers' comp court that the medical provider billed charge is that medical provider's usual and customary rate. So we go after the full $20,000 when we go to workers' comp court, as long as we can justify it through either good payment EOBs from that provider or industry data that shows the provider's charges are reasonable. So assuming the provider's $20,000 of charges is reasonable, we go after that $20,000, the carrier paid $2,000. So now we're in court, in workers' comp court, fighting with the carrier. We're going for $18,000 more, and the carrier is saying the $2,000 was justified. And that's the medical provider claim. That claim can go forward regardless of whether the patient has a separate medical provider, a separate patient claim in workers' comp court. So we can proceed on that basis, and inevitably we come to a settlement of some kind, somewhere between the 2,000 and the 18, somewhere between 0 and 18,000 as a settlement, and it's always at a level that the client, the medical provider, agrees to. So that's how we operate in workers' comp world. So you can, in fact, file a medical provider application without there being an underlying patient claim in workers' comp court. Give us a call about workers' comp. We do some amazing things in workers' comp world. It is a world that is kind to medical providers, much more so than other areas of recovery. So we're here, happy to help you in that space. Give us a call in Paramus, Callagy Law. We'd love to help.